Hello and welcome to our program, The Constitutionally Protected Right to Go Door to Door, How Watchtower v. Stratton Protects Free Speech for All. This program is being streamed on YouTube, along with live Zoom feeds simultaneously serving 10 state bar associations and the country of Jamaica as a continuing legal education program. We welcome the hundreds of attorneys, government officials, jurists, and academics joining the broadcast today on one of those feeds. Now imagine being charged criminally because you failed to get the permission of the government before you knocked on your neighbor's door to talk about the garbage service, perhaps an environmental or political issue, or, as in the case of Jehovah's Witnesses, your faith. Essentially, a 1998 ordinance in the village of Stratton, Ohio, did just that. Jehovah's Witnesses challenged the constitutionality of that law, and the case went all the way to the United States Supreme Court. And on this day, 20 years ago, Associate Justice John Paul Stevens announced the High Court's resounding 8-1 decision declaring the ordinance unconstitutional. In its opinion, the court stated this: "It is offensive not only to the values protected by the First Amendment, but to the very notion of a free society, that in the context of everyday public discourse, a citizen must first inform the government of her desire to speak to her neighbors and then obtain a permit to do so." The ruling naturally had a profound impact on the public preaching work of Jehovah's Witnesses almost immediately. But it also paved the way for all citizens to maintain an open dialogue with their neighbors on any number of issues: environmental, civic, political, educational, or religious, without governmental interference. This program looks back on that historic ruling and how it continues to protect free speech for all. Let's watch as our feature presenter, Josh McDaniel, director of the Religious Freedom Clinic at Harvard Law School, provides an overview of the case and its impact.
The core issue in the Village of Stratton case was the right to go door to door for advocacy. In this case, the Village of Stratton had passed an ordinance making it a criminal misdemeanor violation to go door to door to canvass or solicit for any cause. And the village had interpreted its ordinance to apply to the door-to-door ministry efforts of Jehovah's Witnesses. But more important than that, the ordinance also went far beyond the ministry efforts of Jehovah's Witnesses. It also applied to any type of social or commercial or religious or even political door-to-door canvassing that any citizen might do, going across the street to your neighbors, anything from going door-to-door to sell Girl Scout cookies to going door-to-door to advocate for a political candidate. So the Jehovah's Witnesses sued to vindicate their ability to do this type of door-to-door advocacy without having to first go and register with the mayor's office and receive a permit. And it's important to keep in mind that nothing prevented residents in the village from posting no solicitation signs or no trespassing signs on their yards. When the Jehovah's Witnesses sued, the lower courts initially ruled against them and in large part upheld the ordinance as it was applied to them, and held that the village had an interest in protecting its residents from undue annoyance and potential fraudulent schemes. The Supreme Court then took up the case and, in a very, very resounding 8-1 decision, ruled that the ordinance violated the First Amendment in a substantial number of its applications, and as a result struck down the ordinance. And at this time, there were many other ordinances around the country that were being developed, and that this could have really set a precedent for other towns, cities, villages to adopt similar ordinances that would have really fundamentally altered our expectations about whether we can go door to door, whether we can cross the street to go visit our neighbor and communicate a message to them that's important to us. Municipalities and local government officials should take note of this decision, because it very clearly vindicated the rights of not just Jehovah's Witnesses, but all Americans to go door to door for advocacy. And the Supreme Court was very clear that this is a fundamental, longstanding right. It's not only a right under the First Amendment, the court said, but it's fundamental to the very notion of a free society. And so for the court to say that that is a constitutionally protected right, that even if it's a discretionless permitting scheme, it's unconstitutional for government officials to put that type of a burden on their citizens. They really need to think twice before doing that. It's remarkable. It's hard to point to any other organization, let alone a religious organization, that has had such a profound impact on the shaping of constitutional law over many decades in the Supreme Court. And I think a lot of that can be attributed to what the Supreme Court points out in its majority decision in the Stratton case, that it's because Jehovah's Witnesses, they were compelled by their religious convictions, whereas other citizens, when confronted with some type of issue, might have said, it's not worth it for me to push back against this. It's not worth it to pursue this right. For Jehovah's Witnesses in these cases, they felt compelled by their religious convictions to pursue it, to vindicate it, to make sure that they could practice their religion. And as a result of that, carrying it all the way to the Supreme Court, they've obtained victory after victory and vindicated all kinds of constitutional rights that now Americans everywhere, whether they're religious or not, can enjoy. When the Jehovah's Witnesses do that, when they go to court, when they vindicate that constitutional right, they're not doing it just for themselves and just for their ability to go door to door and do their ministry. It's a right that now extends to everyone thanks to Jehovah's Witnesses.
That was powerful. Thank you, Professor McDaniel, for the excellent overview of the case and for helping us to understand the relevance of the case, not only for Jehovah's Witnesses, but for all. We also thank the Religious Freedom Clinic at Harvard Law School for participating in this program. We've enjoyed the collaboration so far and in this program. We look forward to having you back, Professor McDaniel, in the conversation as we talk about the broader First Amendment issues in the case in a few minutes. But now let's get to the case at hand, Watchtower v. Stratton. With us are the attorneys for the petitioner. On my left, Paul Palladoro, who is a counsel of record and who actually presented the oral argument before the Supreme Court, and Philip Brumley, who is general counsel for Watchtower. Thank you, gentlemen, for being here. Both of you were there on that day, February 26, 2002, arguing this case. But I think we'd be remiss in not starting with the broad overview. Philip, who are Jehovah's Witnesses, and why do they go door to door?
Jehovah's Witnesses are Christians, and we take very seriously what we learn from the Bible. While on earth, Jesus foretold, this good news of the kingdom will be preached. And before he ascended to heaven, he told his followers, you will be witnesses of me to the most distant part of the earth. So the Bible is actually replete with similar texts. There are 8.5 million Jehovah's Witnesses worldwide. Every one of them engages in this public ministry. It's who we are, Jehovah's Witnesses. But apart from being a divine mandate, we also engage in this ministry as an act of love for our neighbor. After all, humanity is facing challenging things, problems, and we think the answers to those problems are in the Bible. It would be selfish not to want to share this with others. That said, Robert, we never want to be intrusive or to overstay our welcome.
So we get that it's a mandate, it's out of an act of love to God and neighbor. But Paul, why not a permit? What's the problem with that?
Well, God told us to do it, Robert. It'd be offensive to turn around and then ask man for permission to do that which God has already told us to do.
It's interesting that you say that because obviously I've done a lot of research in preparation for this, and I recall a comment by one of the seminal cases for Jehovah's Witnesses, Schneider versus New Jersey. And I can remember, I'll just read it here, I have it down, that Clara Schneider, who was an incredible plaintiff, this was hard fought. She was convicted, she went to jail, but she conscientiously believed that to do so would be an act of disobedience to the command of the Almighty God. Now, why would Jehovah's Witnesses, who are more neutral politically, why would you fight in the court for that right?
Well, we follow the example of the first century Christians and the early apostles. We remember Peter, when he was faced with opposition, famously said, we must obey God as ruler rather than men. And when released, resumed the preaching activity, teaching about the kingdom of God zealously and from house to house. We think of the example of the Apostle Paul, who was imprisoned and who also said that he was involved in legally defending and establishing the good news. So we think about his example. When he faced official interference, he said, I appeal to Caesar. He relied upon his rights as a Roman citizen, and when appropriate, we relied upon our rights too.
Philip?
Well, Jesus laid down the rule. He said, pay back Caesar's things to Caesar, but God's things to God. So as a religious tenet, we want to be law-abiding citizens. But when authorities cross the line and ask us to do something that contravenes our faith, Robert, there's no debate, there's no dispute. We are going to fight, and we're going to fight with everything we have. And we're actually following the model, as Paul said, of the first century Christians. Now that said, we've never intended or want to be social activists. Paul also wrote to Timothy that we should pray for those in authority, that we could go on leading calm and quiet lives. So we would like nothing better than to be able to quietly, peacefully go on serving Jehovah according to what the Bible teaches. As a result of this, though, when Caesar does cross the line, when the authorities cross the line and ask us to compromise our beliefs or our faith, well, we can't do that. And as a result, not by design, but over the course of decades, Jehovah's Witnesses have prevailed before the Supreme Court 49 times before Stratton, and with the victory in Stratton, 50 times.
That's pretty extraordinary. Now, think about Stratton for a moment, because taking it to the Supreme Court, Paul, the stakes were high.
The stakes are very high, Robert. When we lost in Ohio, in the district court and then the Court of Appeals, that adverse decision was localized to Ohio and a few surrounding states. But in taking it to the Supreme Court, we then faced the risk of extending nationwide the Supreme Court's granting permission to require us to obtain a permit. Now, we had litigated cases in the 30s and 40s that established our right to preach. So the question was, in 2002, were those cases historical relics, or did they still have modern viability?
So all of this case law from the 30s and 40s that had been built up over time was really, in a sense, put at risk, at least to some degree. Yes, Philip?
Yes. And what we were seeing was that after those victories in the 30s and 40s, for a while, there was virtually no official opposition to our ministry. Mm-hmm. But as the decades rolled by, we saw more and more municipal attempts to regulate our public ministry. It's reminiscent of what had happened earlier in the 30s and 40s. Back then, Hayden Covington was the attorney who most frequently represented Jehovah's Witnesses. And he said something quite telling. I'm quoting from him. Many municipalities had enacted, I'm quoting, a weight of barnacle-like ordinances that virtually nullified the Bill of Rights and wallowed the Constitution in an undemocratic sea. Now that's poetic language, but in plain English, what it means is Covington was saying, of what right is it that the Constitution would have a Bill of Rights if a local town council could on their own enact an ordinance that nullified that Bill of Rights? So one would think that with the victories we had in the 30s and 40s, that the issue of whether we could go door to door was resolved permanently, but that was not the key. That was not the case. As decades rolled by, we saw more and more municipalities attempting to regulate our public ministry, as if those cases in the 30s and 40s meant nothing.
In fact, the Solicitor General of Ohio also joined in the argument before the Supreme Court. What was going on nationwide, Paul, at that time?
Well, nationwide, there were hundreds of municipalities that had ordinances similar to Stratton and were endeavoring to encumber the ministry of Jehovah's Witnesses. So we didn't face that difficulty only in the village of Stratton. For example, we faced the difficulty in Oradell, New Jersey, where not only did they require Jehovah's Witnesses, prior to going from door to door, to obtain a permit, but to wear that permit as a badge. In the first conference we had with the federal court judge, the judge turned to the village attorneys and said, "This sounds unconstitutional to me. You fix it or we will." But we had a much different experience when we litigated in Ohio.
Now, why was the issue so important to the village? What was the premise of this case for them?
They asserted three interests: privacy of the residents, prevention of fraud, and some sort of crime prevention rationale. But as the trial illuminated, there was some bias against Jehovah's Witnesses on the part of some village officials.
Mm-hmm. Well, if you look at the history of the Supreme Court and Jehovah's Witnesses, you'll note over and over again that there were almost in every case, courageous plaintiffs and witnesses. In fact, Stratton was no exception. For years in the village of Stratton, there was a problem. There was a problem preaching for Jehovah's Witnesses. In 1998, they promulgated the ordinance, passed the ordinance, and in that same year, one Jehovah's Witness minister by the name of Tammy Tuckush was stopped on her way out of the village. She had visited somebody that she knew, and she was stopped by the mayor, and he said, "We could put you in jail for this." Let's let her recount that unforgettable experience that changed her life and really set the course for the Supreme Court.
So in June of 1998, me and a couple of sisters were heading to the village of Stratton to stop to see people that we had talked to before. It was probably about like 5:30, 6 o'clock when we went into the town. We were only in there for about a half hour to 45 minutes. The particular ones I wanted to follow up with, I did not get at home, but one of the friends that I was with was able to get a person at home that night and had a nice conversation. And we was approaching the stop sign, ending the evening. I was a passenger, and the sister that was driving, and then of course another one in the back seat. As we passed the Abdullah Tavern and was approaching the stop sign to exit Stratton, is when this gentleman approached our car and was very upset with us of why we was in the town. He came walking out screaming, like yelling or hollering at us to stop. I, of course, had no idea at that time who he was. And as he was very upset and yelling at us, I had asked him who he was, and he told us he was the Mayor Abdullah. We explained to him why we came back, that people had asked us and welcomed us back. And he still was very distraught and upset, shaking so bad that I was afraid of what might happen with him. But he was even wanting to throw us in jail, but since we were women, he wouldn't do that. When we left, thank goodness I wasn't driving, the other sister was, and we got to the Kingdom Hall, and I think we was just relieved to be at the Kingdom Hall. We went into the Kingdom Hall, and I let a brother know. He went and got a piece of paper, and I had a pen, and he had me write down everything that took place, who said what all, happened. My involvement from the beginning of this case was getting prepared for the Ohio court case in St. Clairsville, Ohio in 1999. And then after that, we went for depositions in Columbus. And then both of those transcripts went to the Supreme Court. Because I spoke is why they wanted me to be used in the particular case. I feel very privileged, very precious in Jehovah's eyes to be used as a tool by him. That he's allowing me to have a part in this case that has helped not only ones in that area, but also around the world. We know that if individuals choose for us not to come to their homes, they can let us know that, and we would respect that. As to the governments, if they require us to, it comes back to the things that the apostles said, that we want to obey God rather than men.
Well, 20 years later, she still has the fire.
Yes, yeah.
It reminds me of some of the research I've done to some of these seminal cases, the Clara Schneiders, who we mentioned, Alma Lovell's, Grace Marsh, Roscoe Jones, Billy Goodbitis. All of these cases seem to stand on the shoulders of strong witnesses, strong plaintiffs. How important was Tammy in this call?
Oh, she was pivotal. She helped us show the federal court judge that this was a real-world problem that cried out for a constitutional solution.
And the zeal of Tammy was not an aberration. That's the rule. If you go back to Roscoe Jones, he wasn't arrested once or twice. He was arrested dozens of times. Often he'd be arrested. The mayor would tell the chief of police, put him in jail. When he got out of jail, take him outside of town and drop him off on a country road. Roscoe and Thelma would walk back into Opelika and continue preaching.
We'll talk about Roscoe in a moment. I mean, it is amazing, some of these stories, but it also reminds me that both of you are ministers of Jehovah's Witnesses, but also accomplished professionals. You sat before the Supreme Court. You'd argued a successful case. How do you balance the two, especially when you're preparing for perhaps the most important day of your professional life and maybe even religious life?
Well, we're ministers first,
Yep.
so we make this a matter of prayer, but also we're attorneys. So we had to get our minds around the universe of First Amendment jurisprudence in order to set forth a case that the Supreme Court would accept.
And we approach this litigation not just as a mere legal battle, but as an expression of our faith, Robert. We didn't want to give God a mediocre or half-hearted gift. We wanted to do our very, very best. And actually, the individuals who prepared the pleadings, that was Don Ridley, Richard Moog, James Deffabaugh, Paul, and me, before we would ever put pen to paper, every morning, we would first offer a supplication to Jehovah. Help us to do the best we can.
Interesting. James Deffabaugh, you mentioned.
Yes.
Senior paralegal to the team. He was there with you all the time, including at the Supreme Court hearing. We had the chance to catch up with him. In fact, we had an extensive interview with him remotely. And he talked about the case, and he talked about February 25th, 2002, the night before the case. How did you all feel? He describes the feeling right here.
It's almost like you feel the gravity of what can be decided on that day. And so there definitely was some nervous anticipation because we were concerned that, and we knew the risk in taking the case to the Supreme Court was, will they actually erode the protections in the 40s, or will they take it the one step further that we were asking them to take it? There's a knot in your stomach because you have no clue how it's going to go. And you're waiting for the case to be called. And we know what's at stake because hundreds of municipalities already are trying to enforce permit laws on us and other types of laws that we know if we lose, it's just going to explode across the country. And it isn't really a little thing because these laws that were already trying to be enforced were so erroneous and such a hindrance to the brothers preaching. Some of the laws, they had to go, every time they went to preach, they had to go to town hall to pick up badges, give names of publishers going door to door. And so a lot was at stake because it would go from those few hundred towns to all over the country. We would have similar type of problems.
There was a knot in my stomach.
Yes. Yes.
Is that the way you felt, Philip?
Absolutely.
Yeah,
Absolutely.
We saw you on the steps of the Supreme Court with Paul. What was the basis of your argument? What did you go there with?
Well, the thrust was very simple, and that is that the First Amendment protects the right to speak to one's neighbor without the involvement or interference of the government. And we put forth the point quite clearly. This is not just for Jehovah's Witnesses. This is a right that everybody in this country enjoys. As you mentioned earlier, the right to go to your next door neighbor and talk about whatever's on your mind. Now, the authorities had argued, Robert, that the ordinance in question didn't abrogate or infringe upon that right. They were saying...
and in fact, the two lower courts upheld the ordinance.
That's exactly right, because they said the ordinance is free, there's no fee, and giving the permit is not discretionary. In other words, they were saying all you have to do is show up and get the permit. That's all you have to do. But if this ordinance had been upheld constitutionally, it would have opened the door to what we would call veiled prejudice. Now, just think about this a minute. Stratton has less than 500 inhabitants. So if the ordinance had been upheld, who would the police have stopped to ask for a permit? Not the trick-or-treaters or not the neighbors that they knew, but so-called outsiders or people that they viewed as being unfavored in town.
So right in that point alone, there was discrimination.
Absolutely.
Even though the permit, there was no discrimination, so to speak.
And then,
even the point of who they would stop.
Yes.
I think by the time it went to court in 2002, there were like 12 people who had applied for a permit. So clearly, people like trick-or-treaters didn't apply, even though they should have under the ordinance. Clearly, others who were going door to door didn't apply, and there was no enforcement. The enforcement was only on a Jehovah's Witness minister. And
think about it too. There's all kinds of ways to say we can't give you the permit. Mm-hmm. I'm sorry, the office is closed, or I'm so sorry, but we ran out of forms. All of a sudden, discretion is once again introduced, allowing the authorities to pick and choose who they would allow to go door to door in their town.
Paul?
No, I completely agree. There was evidence of animus and bias, but also when you looked at the ordinance accompanying the statute in question, it mentioned Jehovah's Witnesses specifically. So we were very much on the radar.
The district court took that out, right?
They did, but it was evidence of what witnesses were facing in that community.
What the premise of it was to begin with. Interestingly, that on those two lower court levels, they did uphold. Did that make you fearful, Paul, going down to the Supreme Court when these two lower courts, these two lower federal courts, upheld the ordinance?
Well, obviously, you go behind the eight ball a little bit, as it were. But there's two pieces to this puzzle, Robert. There's the religious piece that we rely upon Jehovah, but also there's the legal piece. Jehovah's Witnesses in the 30s and 40s created a mountain of precedent protecting freedom of speech, freedom of press, freedom of religion. And so the question was, could Americans still rely upon that? Could Jehovah's Witnesses still rely upon that to speak to their neighbor about one-on-one intimate communication about God's Word?
Mm-hmm. Now, it didn't automatically get escalated. I mean, there was some level of negotiation with the village, wasn't there?
Always. There's always dialogue and discussion. It's not, we don't first jump to litigation. We always seek a peaceful way to try to resolve situations. So there were discussions not only before the district court hearing, but also before the Court of Appeals hearing for the Sixth Circuit in Ohio.
Well, let's get to the day. Let's go back to Mr. Defabaz. He reflects on the opening argument. Your opening words, Paul, started with a knock on the door. Let's hear him recount it.
There was some question, should Paul start the argument like it's a door-to-door presentation in the ministry? And it was nice to see that the justices, no one interrupted through that whole first part of his presentation, and they showed great respect.
It's 11 o'clock Saturday morning in the village of Stratton. Good morning. In light of recent events, I've made a special effort to come to your door to speak to you about what the prophet Isaiah has referred to as the good news of something better. That's the good news Christ Jesus spoke about, the good news of the kingdom of God. It is a criminal act to go from door to door in the village of Stratton and deliver that message unless one has first obtained a permit from the village to do so. It is also illegal to go from door to door and hand out a leaflet that says, "Democracy is wonderful. Please vote next week."
Well, Paul, you've knocked on a lot of doors probably in your life as a Jehovah's Witness minister, but that was probably the most consequential knock you've ever had.
I would think so, Robert.
What were you thinking in opening with what some would call a Jehovah's Witness sermon?
I wanted the court to see what was being criminalized. That simple notion of a citizen going to the door with a Bible-based message of hope, peace, and comfort was a criminal act unless the individual obtained a permit. But that law also extended to political discourse. So someone who wanted to engage in anonymous political speech would likewise be committing a criminal act if they went to the door and said, "Vote for Robert Hendricks in November."
I hope they never go to the door saying that. But let me ask you this, because it really surprised me that immediately Chief Justice Rehnquist just pounced on you after that. It was, and then the entire time, all we're hearing is back and forth between them, between you. How do you prepare for something like that? Do you have a time limit? How do you prepare for that?
Well, only the opening is well rehearsed and prepared. I had notes designed to take me to different topics or subjects should they come up. But one of the best pieces of advice I received in preparing for the oral argument was from a professor at Georgetown Law School, who said to me, "Paul, the president will never invite you in the Oval Office while he's making a decision that impacts you. Congress will not invite you into their inner sanctum when they're making decisions. But the Supreme Court, the longest amount of time they spend discussing your case is when you are in front of them, and they're inviting you to be part of that process." So in my mind, it became a collaborative endeavor, a dialogue, as it were. Now, that didn't mean that some of the questions weren't combative. They were. But it's
they certainly were.
They were. But it's a communicative process. And at times, the justices spoke to each other through you.
Mm-hmm. Well, we'll talk about that in a moment. It's interesting that on October 15, 2001, that's when the court granted certiorari to this case and allowed you to argue your case before the court. This next exchange seems to crack the door open to go beyond the question that was at hand. The question that was certified was the one on political speech, anonymous political speech, which may surprise some regarding Jehovah's Witnesses. But let's listen to this first audio excerpt of the case and give a little sense of why the door might be cracked open to something bigger than just anonymous political speech.
Your Honor, we are not suggesting at all that a resident cannot post a no trespassing sign and keep all the way from their door. However, in order to get the right to go to that door, one must go to the mayor, give his name, give a brief description of the cause they want to speak about, as well as their associational affiliation. We believe that this court in McIntyre said there's an interest in having anonymous works enter the marketplace of ideas, and that unquestionably outweighs any interest in requiring disclosure as a precondition to entry.
Well, do you focus on the right of anonymity or the right of unrestricted speech as of the time you get to the door or when you go to the mayor's office? Because our most recent cases talk about going to the door. And that's where your brief focuses on it. It seems to me that what you've begun with, and it's also troubling to me, is that you have to make the disclosure to the mayor as well. So I take it those are two different parts of your case.
Correct, Justice Kennedy.
But you emphasize only the latter, really, in your briefs. Are the records that the mayor keeps, are they open to the public?
They are absolutely indeed, Your Honor. Under Ohio state law, those records are open to the public. So anyone would be able to go to look at the record, which would include the name, your message, and your associations.
You would have no objection to this statute if you didn't have to give your name?
Your Honor,
perfectly okay to say you can't talk to anybody without getting a permit, so long as you don't have to give your name when you get the permit.
Your Honor, we believe the name is the constitutional infirmity indeed.
That's the only problem. So if this were revised somehow so that all you had to give was a reference, maybe somebody in the community who would vouch for the integrity of these Jehovah's Witnesses, that would then be okay. Because
no, Your Honor.
The only problem is that they have to give their name. You see, I would have thought you would have objected to the necessity of going to the mayor and saying, please, Mr. Mayor, can I talk to your citizens going house to house? But that's not your problem. Your only problem is that you have to disclose your identity.
No, Your Honor. We do not believe that anyone needs to go to the government for permission to speak to their neighbor about any message. Yeah. Most importantly, a message.
That's the stronger part of the case.
Yes, Your Honor.
Now, some in the audience might have missed Scalia saying that's the strongest part of your case. But clearly, Justice Scalia was opening the door here. I mean, you were talking about McIntyre versus Ohio Election Commission. That was a case on anonymous political speech. But it would confuse most people because most people know Jehovah's Witnesses have no problem giving their name. What was the issue?
That's correct, Robert. The United States Supreme Court takes cases based on questions presented. Mm-hmm. What's the legal question that is presented? The first question that was presented was the impact of the ordinance on Jehovah's Witnesses' free exercise of religion, speech, and press. But during the course...
Well, that makes sense, right?
Makes perfect sense.
Typically, a religious organization would go and deal with the free exercise clause, not the free speech clause, right?
Correct. Right. Correct.
So what happened here?
Well, during the course of the briefing, it became clear that if Jehovah's Witnesses needed to obtain a permit, so too did anonymous political speakers. The First Amendment is so powerful that the court says, even though that's not your right, though that's not your interest, we'll allow you to assert it so that we can defend the First Amendment. However, there was a little bit of question about whether we should have put that in the case.
In fact, didn't you have a consultant who was a consultant for the Supreme Court? You brought them in to give you some advice, and they said, don't go with this second question. They told you to go with the free exercise, not the anonymous political speech. Yeah, am I right?
Yeah, they were stronger than that. They said, if you put this anonymous political speech as a question presented, you will convey to the court that you don't know what you're doing. Your petition will never get past the clerks, to the justices themselves. But I saw it so clearly, Robert. I prayed to Jehovah. I said, Jehovah, please, I see this so clearly. I'm going to speak to the attorneys again to help me see where I'm wrong.
So that's where faith and your professionalism kind of merge. They're intersecting now. So you go with this second question. What happens when you get when you gain certiorari from the Supreme Court?
Supreme Court granted cert only on anonymous political discourse. Did not accept the question presented based upon our free exercise of religion.
And now to go back to Justice Scalia, it's likely because of Justice Scalia, right?
That's exactly the point. With Scalia's comment, we saw that the door had opened for us to discuss squarely how this ordinance impacted on our activity. And Robert, from that point on, anonymous political speech ceased to be the topic. It got really square to what are Jehovah's Witnesses doing and how does this impact on your activities? Well, with that door open, we were able to not have to tiptoe around the anonymous political speech, but get right squarely to the point of our public ministry.
Now the Buckley case does come up later, and that's the second precedent-setting case about anonymous political speech. So we'll get back to this issue of the question. But one of the primary arguments that the village cited as a reason for the ordinance was community safety. Both Justice O'Connor and Chief Justice Rehnquist seemed to be sympathetic to this argument. Let's go back to James Defabaugh as he reflects on this key moment in the case, where we'll hear Justice O'Connor first, but then we'll also hear Chief Justice Rehnquist talk about how this ordinance might impact on community safety.
We kind of anticipated that Rehnquist would probably be against us, because I think what Rehnquist was saying articulated our fear of, is this how the judges will view things in a post 9/11 world?
Do you think that the practice around the country of various towns and cities is to require permits for people to go door to door in residential areas? I think I even live in a community that probably does that. The concern may stem from a concern about preventing burglaries and unfortunate incidents in the area. And they want to identify the people who are going door to door.
Justice O'Connor, my experience is quite to the opposite, that after the battles between Jehovah's Witnesses and municipalities in the 30s and 40s, municipalities have stopped attempting to regulate Jehovah's Witnesses by forcing them to get a permit to go from door to door. This is an experience that we're having in the past few years, that more and more municipalities are now requiring not only a permit, but as Justice Scalia touched on, fingerprinting, photographs.
There was a story in the paper just last week here about the double murder up at Dartmouth, how the kids who did it went from house to house purporting to be taking a survey, and then what they were actually doing was casing the houses for robbery. So that's certainly something that a municipality can take into consideration, isn't it?
Chief Justice Rehnquist, we think it's implausible to think that someone intent on committing a violent crime would stop at the City Hall to get a permit or in any way be deterred. And in the circumstance Your Honor posits of someone just going door to door and observing or taking notes, the ordinance in this instance doesn't prevent that. The only time the ordinance comes into play is if you speak.
But it does give a record of who it was, which would probably deter someone.
The question was, I guess, really when Rehnquist was going down that line of questioning with Paul, is how many sympathize with his arguments?
Talk about sympathize. Clearly, O'Connor was intrigued by the issue because this just happened the other day. I think it was it was yesterday. I was listening to oral arguments again right in my ears, and as Chief Justice was talking and making these assertions regarding Dartmouth, you heard Justice O'Connor twice go, good thing you didn't hear that. So this was a post 9/11 world. Was there a fear, Philip, that perhaps the justices would be sympathetic to this argument?
Well, that was exactly the point. This was post 9/11, so there was a concern for safety and avoiding crime, fraud. The authorities made this a cornerstone of their argument, that the ordinance should have been upheld because it would be protected against crime. The fact, though, Robert, is that the ordinance did nothing to protect crime.
In fact, Paul, I think your response to the Chief Justice was very powerful. Did that put the issue to rest at this point? And why do you think the issue did not resonate with the rest of the justices, as can be seen in the actual decision?
Two reasons. One, you mentioned the decision. Justice Stevens said, really, it is implausible to think someone who's going to commit a violent crime is going to be deterred by a permit ordinance. And with respect to Stratton, there was no verification mechanism to know who was obtaining the permit. I could go and say, I'm Philip Brumley, give me a permit. They would give me a permit in Mr. Brumley's name. So the ordinance did nothing really to prevent crime.
Well, we get off that issue and get back to anonymous political speech. Things seem to get interesting during the discussion of the Buckley case, which, of course, is the second precedent-setting case in anonymous political speech. That involved volunteers in Colorado doing electioneering, gathering petitions. Justice Scalia seemed to cut off this line of questioning, saying that using the case was a poor example. Let's go back to James Defebaugh. He has some reflection on how Justice Scalia interacted and what this meant for the rest of the argument.
At that point, Justice Scalia said to Paul, why don't you just tell her that it was a bad example and move on?
Because of the compelling governmental interest that's involved, Justice Ginsburg, and that's the distinction. When we have one-on-one...
That doesn't handle your example. I mean, why don't you just say it was a bad example? You shouldn't have used the example.
Is it
not worth your time? You shouldn't have used the
yes.
example of a petition circulator. You are concerned about people who just want to come up and say, I want to talk to you about why you should vote for Smith.
That's correct.
Is that the case?
It is indeed the case.
But thank you.
And so she asked no more questions after that. And the issue was dropped. She could see that we weren't trying to push the agenda that would affect the cases that she had authored. And the whole demeanor of the court seemed to change after that. I don't believe, from my memory, that Justice Rehnquist raised any more issues after that short window of questioning that he brought. And the tenor just seemed much more positive after that. And it started to feel like, okay, maybe there are a number of them that they get it, they understand what we're trying to say, and they might actually rule for us, a number of them.
So as much as there was some concern or just kind of bewilderment as to why this was your issue, Justice Scalia seemed to shut down the whole Buckley case because, of course, you use that in your pleadings. But describe what's going on here.
Well, since the court accepted the case of anonymous political discourse, we had to rely on that case law. So you mentioned McIntyre earlier. Mrs. McIntyre wanted to hand out leaflets without her name about a political message. The Supreme Court said she had every right to do that. Buckley also involved, in some ways, anonymity. So we were compelled to use that. However, Justice Ginsburg authored Buckley. So she was concerned, I believe, that the decision in Stratton might in some way undermine her decision in Buckley. And what Scalia was doing was really helping us out.
Right.
I think communicating to Justice Ginsburg, Buckley's okay, and communicating to me, understand, we've taken the case in anonymous political discourse, but we know you are who you are, and we're going to allow you to speak to that.
So, I mean, even it seemed that Ginsburg was saying this doesn't work. Buckley doesn't work for you.
Right.
So, but Scalia was saying, just tell her it was a bad example. Just tell her it was a bad example. Why would you use it if it was a bad example?
Well, we had to use the cases on anonymous political discourse because that was the question that the court presented. That's what got us into the door. But Scalia effectively terminated that line of inquiry, and for Justice Ginsburg, satisfied her on Buckley.
Mm-hmm. Philip, how important is this crosstalk between the justices?
So exceedingly important, Robert. And you see at the beginning of the discussion that Rehnquist was clearly not in favor of our proposition. And we saw as the case, the oral argument unfolded, didn't appear that others were in favor either, O'Connor and Ginsburg. But precisely because of that crosstalk between each other, Paul at times almost like an observer as these justices were expressing their views, we saw that shift where first O'Connor and then Ginsburg started to favor what we were proposing and our position. And so we could see that the argument was really going in the right direction and the judges were going our way.
Well, the oral arguments seemed to wrap up on a high note with the facts of the case crystallizing in the minds of the justices. In fact, they even seemed to be playful at the end, ending up on a real high note. Let's go back to James Defebaugh as he introduces this exchange between Paul and the justices.
You know, it seemed like he was in very good control to me at that point in the argument, and he had become relaxed and calm and seemed in control.
No, I'm confused here. I had thought that you object to this even if the name doesn't have to be disclosed, and even if there is not excessive discretion given with the mayor.
Exactly.
It's not your objection that you do not want to have to go to City Hall in order to ring doorbells.
Right. Precisely, Justice Scalia.
No matter what.
Precisely.
They want you there because they know at least you'll find out which homeowners don't want people around. And you'll read what the rules are, all right? Is that good enough?
Justice Breyer, we have not contested that provision of the ordinance. Section 11607, which allows a homeowner to post a no solicitation sign and then go to the village and say, I want this group and not this group, has not been contested.
But your position is, of course, that governments always want to know what its people are thinking, but they don't have any right to find out.
Well, that's an expression of the residents' interest in who they want. It's not the government making the decision for them. Now, with respect to the...
I'm talking about your clients.
Your Honor, we...
Take it. It's good.
Okay. I think that's an appropriate point, Chief Justice Rehnquist asked, if I may reserve the balance of my time.
When he got to a good places with the justices, don't overstay your welcome. Sit down and reserve your time in case you need it at the end.
I think that's a good time to reserve my time. I thought that was really Scalia. Justice Scalia was obviously kind of micromanaging this case all the way through from the beginning. But when you crank up the volume, and this happened to me on a different bike ride, listening to the oral arguments, you hear right at this point, you hear somebody saying, reserve time. Now, you don't remember this, but Philip, you do.
So it's not like the justices line up and ask their questions nice and neatly one at a time. The justices were peppering Paul simultaneously with different questions, and the adrenaline was flowing. We could see those lights flashing that said you have 30 seconds, you have 15 seconds. Paul was still engaged, and I do remember leaning over, hey, reserve your time.
So, Paul, why now? Why at this point?
Well, I was in a zone with the courts. I didn't hear Philip, but I was paying attention to the lights. I knew my time was expiring, but I also saw the comportment of the court. They were done. And I heard what Justice Scalia said, and it seemed like a positive note. When you don't have anything else to say, just shut up and sit down.
Do you think that at that point, Justice Scalia was with you?
Yes.
I mean, was that your feeling, Paul?
I felt that he would have been very favorable to a free speech claim going in, and I felt that he maintained that position throughout the argument.
So opposing counsel begins his argument. First of all, it's the village attorney, then the Solicitor General. And the justices seemed to be ready to challenge, and challenge they did. James Defebaugh remembers this moment well because it was a point in the case that he began to feel good.
So when the Solicitor General for Ohio got up and the justices started tearing into him pretty quickly, it became pretty apparent that more than we thought maybe were seeing things from our perspective, and that this idea of having to go to the government before you talk to your neighbors is just ludicrous to them. I will say this, I felt as much as the court went after him, the Solicitor General did a fairly decent job with what he was dealt by the court. But then when the attorney for the town got up, it just went to a whole other level of bad for the other side.
Do you know any other case of ours that has even involved an ordinance of this breadth, that involves solicitation, not asking for money, not selling goods, but even, I want to talk about Jesus Christ, or I want to talk about protecting the environment? Have we had a case like that? I mean,
there is.
The mere fact that I'm unfamiliar with something like that, maybe they've become current now, but the mere fact that I don't even know of such cases over 2 centuries makes me wonder.
So,
do you know of any?
Your Honor, there is no holding by this court that identifies this.
Never mind a holding, a case in this court involved. The breadth of this thing is novel to me.
There is no case that identifies the breadth of this case, but perhaps that might be part of the beauty in the sense that it is content neutral, and that
you think it's a beautiful idea that I have to ask the government for permission before I go down the block where I don't know all of the people. I wave to them, but I don't really know them. I say, I want to talk to you because I'm concerned about the garbage pickup, because I'm concerned about our congressman, whatever. I have to ask the government before I can do that?
No, Your Honor.
Astounding.
No, Your Honor. What we are talking about are canvassers, hawkers, and those who are going door to door for a cause.
Well, how about trick-or-treaters? Do they have to go get a permit?
Ooh, that was painful.
That was painful.
Well, when you heard that, Philip, did that surprise you how the justices just were so combative?
So when we went in and Paul started talking, we didn't know which way the court was going to go. But as his argument unfolded, we saw the justices were understanding what we were trying to say and were sympathetic to what we were saying. It was a completely different picture when those who were defending the ordinance stood up to argue their case. Really the derision that the court manifested towards the ordinance when the justices said, "You think it's a beautiful thing?" Really? So it was clear that the court was going our way.
Couldn't have said a worse thing. That brings me, Paul, to your final rebuttal, because it seems to me that you listen now to the answer from opposing counsels, and then you get up for 4 minutes, and it seems to me your rebuttal is almost like a rationale for the case in miniature. Let's listen as we bring up on the screen as Paul rebuts the argument of the respondents.
And lastly, Your Honor, I've heard our door-to-door activity be referred to as an annoyance, to be compared to obnoxious picketing at the home. I respectfully suggest that our activity indeed lies at the heart of the First Amendment.
So, final statement. Did you write that out, or was that a true rebuttal?
No, absolutely a true.
And why? Why?
Absolutely a true rebuttal. My training as a young prosecutor, you listen to the case and you speak to what you consider important. So I listened to what was being said. One, I found it offensive that our ministry was being spoken about in a demeaning manner. But two, I wanted to remind the court that this was core First Amendment speech that deserved its protection.
Lies at the very heart of the First Amendment. Right. When you rested with those words, of course, they had some questions. Did you see a reaction from the justices?
Yes, I saw Justice Scalia was pleased.
In fact, what did you feel like at that point? Were you relieved when you saw his reaction?
Yes, he smiled at me like I was his nephew and he was my uncle. It's very hard to explain.
So
Robert.
It was like a Sunday pasta dinner with the whole family kind of arguing, and then
we're going to have you over for pasta. We'll have you over for pasta,
Okay.
Robert.
Well, as you both mentioned, Jehovah's Witnesses have been very active in the Supreme Court and establishing First Amendment jurisprudence in the 30s and 40s especially. Philip, what role did some of those precedent-setting cases have on the outcome of Stratton?
Well, that laid the very foundation. When you think back to those cases in the 30s and 40s, Lovell versus Griffin, Cantwell versus Connecticut, Jones versus Opelika, Murdoch versus Pennsylvania, you could go on. In each case, what was involved was a very zealous Jehovah's Witness who wanted nothing more than to just talk to others about his faith or her faith. And so the question was, are those cases still good law? They formed the foundation, and Stratton said through this beautiful decision, those are still good cases.
So one of those early cases was Jones versus Opelika. In fact, it was a very powerful case, and the case involved a Jehovah's Witness minister by the name of Roscoe Jones. Roscoe Jones was a person who was arrested for being on the street preaching about the kingdom of God. It was the city of Opelika, Alabama. They had charged Jones with violating its licensing ordinance by selling books without a license. And this went all the way to the Supreme Court. And in 1942, the Supreme Court upheld the conviction. Interestingly, in the following term, after Jones 1 was decided, the court heard a re-argument in the Jones case and consolidated other cases, including a key landmark case, Murdoch versus Pennsylvania. In Jones 2, the court struck down as unconstitutional city ordinances that required Jehovah's Witnesses and other religious proselytizers to pay a license fee to practice their religion, thus reversing Jones 1. The opinion stated that the license tax restrains in advance those constitutional liberties of press and religion and inevitably tends to suppress their exercise. Well, we found a man who knew Roscoe Jones, in fact, lived with him and his wife for a time. His name is Lawrence Reed. He is a Jehovah's Witness minister. He is now 99 years old, and he says the case changed the city for good. We had a chance to get his reflections on what it was like to preach in Opelika before the Jones decision and what it was like to preach there after. Let's take a look.
Roscoe Jones came over with his wife, and they stayed with us, with me and Sister Reed. When you heard him talk, his voice had a strong voice, convincing, you know, and he was just a bold guy. The 2 weeks he stayed with us, and the time he was in Opelika, really, he was an outstanding man. He went door to door in Opelika, and he would boldly talk to, which was something unheard of. Jehovah's Witnesses knocking on a door in Opelika, you would end up in jail or beat up or cussed out or, you know. So the police came and arrested him.
I said, well, what's our charges? He says, all you are charged with blocking the sidewalks of Opelika. We have ordinance against it. I says, man can't stand on the sidewalks in Opelika? No, he can't stand on the sidewalks of Opelika. And he locked us up.
Roscoe Jones was not afraid of the police. In fact, many of us wondered how he could stand, because police at that time were very mean. Police were very mean. And this frightened a lot of us. We feared that this would be the end, that the police would really crack down. When the police arrested him, instead of him stopping, he told them no. He gave them a witness, and that was a picture in the paper they took was Roscoe Jones versus the city of Opelika. He made a court case out of it. The society sent down a representative. And they said, sure, that these people can go on the street, and he ended up winning it too. They won it.
When the decision was made in our favor, it released a great multitude of Jehovah's Witnesses that had been put in prison or had been sentenced to prison for preaching the good news of the kingdom without a license. And the Supreme Court decided Jehovah's Witnesses didn't need a license fee.
And when they dismissed it, it gave us a new life. It opened it up. And many of our sisters who would say, man, Brother Jones is going to that door, and they would follow him. They would go to the door. I remember my wife going door to door for her first time. She was saying that this was all because of Roscoe Jones. Now that we could go to somebody's door and knock on the door and offer them a magazine. Roscoe Jones opened up Opelika.
Oh, we are now joined by Professor Josh McDaniel, who is the director of the Harvard School's Religious Freedom Clinic. Thank you for being with us, Professor McDaniel, and thank you for being a part of our conversation today. You know, it's pretty extraordinary to be able to look into the past, hear the actual voice of Roscoe Jones, and talk to a witness who actually knew him. Tell me about Roscoe Jones.
Well, it's good to be with you today. Roscoe Jones was a heroic individual. He's been called the grandfather of the civil rights movement. And he, as a black man, would go from town to town in the South in all white areas and preach and face tremendous opposition when he did so. He was threatened, he was physically beaten, and in the Jones case itself, he was criminally charged for his preaching efforts. And as a result of his efforts in the courts to vindicate his rights, he paved the way not only for decisions like Stratton, but also for civil rights litigation itself.
People like this are amazing to me. In preparation for our program today, I read Armed with the Constitution by Merlin Newton. And this author writes about Jones. He said, he won by believing in the righteousness of his cause and standing with the courage of a Daniel. And then talking about many of these Jehovah's Witnesses who stood before the court, it says, their dedication often shamed their opposition. By nonviolent means, they persuaded the Supreme Court and the nation to examine the true meaning of the First Amendment. Professor McDaniel, how important was this case to First Amendment jurisprudence and even all the way up to the Stratton decision?
I'd say it's very important because it marked a very fundamental shift in the Supreme Court's approach to the First Amendment in the 1940s. You started off the decade with a decision, now infamous decision, called Gobitis, one of the flag salute cases, where the Supreme Court, in an 8-1 decision, ruled against Jehovah's Witness children. And that was followed up shortly by this decision in the case by Roscoe Jones, where the court also ruled against him. And around that time, you had several justices that were already starting to reevaluate their views and starting to question, was this the correct approach? Then you have Murdoch, and you have the rehearing of the Jones case, and ultimately the West Virginia versus Barnett case that reversed the original flag salute case. And in all of these cases, the justices are rethinking the First Amendment, and especially the exercise of religion and the free speech clauses that applies to the exercise of religion. Fascinating.
It's interesting that this was decided at the same time as Murdoch versus Pennsylvania. What's the significance of that? It was just a one-paragraph per curiam that was kind of attached to the Murdoch case. Significance?
Well, I think it's significant not only in terms of recognizing the right, which would lay the foundation for the Stratton decision that we're discussing today, but it's also, like I said, about the views of the court. The views of the court were being shaped, and as some of the justices noted, they were moving away from viewing religious activity as something akin to commercial activity and thinking of it more as core religious activity, something that should be protected, something that has a preferred place within the Bill of Rights.
It is amazing that Stratton decision, that favorable ruling, was the 50th favorable ruling for Jehovah's Witnesses. What did these victories, these 49 other ones, what effect did it have on defining and even expanding First Amendment freedoms, and what effect did it have on the Stratton case?
Well, they certainly laid the foundation for the Stratton case. They incrementally, from case to case, recognized and broadened First Amendment rights, especially when it comes to door-to-door going and speaking to your neighbors, whether it's about religion or about anything else. And like we discussed earlier, it also laid that foundation of recognizing that this type of door-to-door advocacy is also a key way of exercising religion itself. It's a historically rooted religious exercise that should receive core protection under the First Amendment.
Are you surprised that one organization could have such an impact on First Amendment jurisprudence?
Well, looking back, it really is arresting. If you look at the number of victories, these 50 cases that were brought, all the victories that they had, I'm not aware of any other organization that's achieved those types of results.
Philip, why was there such a flurry of cases in the 1930s and 40s for Jehovah's Witnesses?
That's an excellent question because it refocuses the consideration to the plaintiffs. So the justices didn't just as an intellectual exercise decide to change their minds. If you just go back in history a little bit and look at the 20s, that's when Jehovah's Witnesses really organized our public ministry. The congregations at that time were quite small, 15, 20, 30 congregants. And as we engaged in our ministry, usually there was no resistance. But then pockets of resistance started to appear, and Jehovah's Witnesses started to get arrested. Now, we didn't have enough attorneys to represent all of these Jehovah's Witnesses, so a publication was produced, Order of Trial. And that was a fascinating thing because it taught each one of Jehovah's Witnesses how to defend themselves in court. So we didn't have to worry about sending a judge to the trial court. It even showed the witnesses how to file their own appeals.
You couldn't. There were hundreds of cases,
exactly
right? You went out in the ministry on a Sunday and you brought your toothbrush, right?
As a matter of fact, during the 30s and the early 40s, of the witnesses in the United States, 1 in 9 was arrested every year. Just for the public ministry. So when the cases went against us momentarily, it didn't stop our preaching work. And the justices saw no, Jehovah's Witnesses are going to continue doing their work no matter how often they're arrested. And going back to the flag salute issue, there was no question whether Jehovah's Witnesses were ever going to say, oh, the Supreme Court says we have to recite the flag, we might as well recite the pledge, we might as well do it. Of course not. The Supreme Court saw, regardless of what we say, witnesses are not going to be forced to say something they don't believe. As a matter of fact, Professor McDaniels is exactly right. Others have recognized the importance of these cases. Professor McAnich, who wrote in the Cincinnati Law Review, he said this, if ever an organization had a successful day in court, it was May 3, 1943, on which the court decided 13 Jehovah's Witnesses cases. The witnesses prevailed on the merits in all of them. But then he adds this, in agreement with Professor McDaniel, Jehovah's Witnesses have had a profound impact on the evolution of constitutional law, particularly by expanding the parameters of the protection for speech and religion. They expanded the right to speak, that's going door to door, and established the right to refrain from speech. That's the flag salute issue. We won so many cases in the 1940s that the issue virtually disappeared for decades.
Well, let's get back to win number 50.
Yes.
Stratton. 20 years ago today, June the 17th, 2002, Justice John Paul Stevens, he announced the decision of the court. Now let's listen to that decision.
This case comes to us from the United States Court of Appeals for the Sixth Circuit. The petitioners are Jehovah's Witnesses who go from door to door distributing religious materials. They brought this action against the village of Stratton, Ohio, challenging the constitutionality of an ordinance that prohibits canvassers from going on private property to promote any cause without first obtaining a permit from the mayor's office. The district court upheld the ordinance and the Sixth Circuit affirmed. We granted certiorari to decide whether the ordinance violates the First Amendment. We note that the ordinance covers far more than commercial activity and the solicitation of funds. It applies to religious and political activity and would seem to extend to the spontaneous speech on a Sunday afternoon of a neighbor who decided to ring a neighbor's doorbell and ask him to vote against the mayor at the next election, or something like that. For reasons stated in an opinion filed with the clerk, we conclude that the ordinance is a species of a prior restraint that is not tailored to protecting the village residents from fraud, from invasions of their privacy, or from crime. We therefore reverse the judgment of the Court of Appeals. Justice Breyer, joined by Justices Souter and Ginsburg, has filed a concurring opinion. Justice Scalia has filed an opinion concurring in the judgment in which Justice Thomas has joined, and the Chief Justice has filed a dissenting opinion.
Well, we're joined by Keturah Dunn, who is Associate General Counsel for Jehovah's Witnesses. Welcome, Keturah. Keturah, you were a lawyer for just 18 months at the time of this hearing, and you got a chance to actually sit in the courtroom. What was it like?
It was thrilling. It really was thrilling to see it happen.
Now, just what, 4 months later, comes an 8-1 decision. Were you surprised?
You know, the 8-1 decision was somewhat surprising. At oral argument, there was definitely a majority that appeared to be in our favor. But given the security concerns after 9/11, we just really didn't know how it would play out. I mean, it could have been a weak decision, a simple majority, and a win is a win. But this was an 8-1 decision, which meant it was a robust endorsement of the constitutionally protected right to go from door to door. And it really sent a strong signal to state and municipal officials who may have sought to restrict door-to-door advocacy.
Professor McDaniel, 8-1 in Stratton. How important was that?
Well, I think it's tremendously important because it's showing that this is not a split decision of the Supreme Court. This is really an overwhelming decision in the claimant's favor, and it shows it's a consensus decision. But I think it's also important to note the shift from the 1940s to the 2000s, where you go from not only having 8-1 decisions against the Jehovah's Witnesses in the Gobitis case, and then you're barely eking out a win in the later decisions in the 1940s. But now here we are in the 2000s, and you have an 8-1 victory for the Jehovah's Witnesses on this core issue.
Mm-hmm. Gobitis or Murdoch 5-4, Philip. Jones versus Opelika 5-4, Martin versus Struthers 5-4, West Virginia Barnett 6-3. It could have gone differently with Stratton, but instead it seemed to have ensconced those rulings rather than vacate them.
Yeah, and as the Supreme Court handed down more and more rulings, more and more those rulings were not 5-4 decisions. There were 7-2 and 8-1 decisions in our favor. And so it was with the Barnett decision, 7-2. So clearly the Supreme Court was going our way, recognizing our rights.
Professor McDaniel, what was the basis of the Stratton decision then?
So the Supreme Court moved beyond the free exercise clause and focused on the free speech clause. And the court held that fundamentally you have a right to cross the street and go talk to your neighbors without getting permission from the government. And the ordinance here was invalid in so many of its applications that the court struck down the ordinance in its entirety.
Keturah, the basis of that decision.
Well, the Stratton decision also relied on Schneider, which was our first case involving the door-to-door ministry of Jehovah's Witness, and another 8-1 decision. And just to underscore the relevance of Schneider to the Stratton case, our merits brief compared the two ordinances. And this side-by-side comparison revealed that many of the provisions of the ordinance in the village of Stratton were virtually identical to those that had been enacted 60 years earlier by the town of Irvington, New Jersey. So this really underscored and emphasized the ongoing relevance of the older cases from the 30s and the 40s to Stratton.
Paul, it seemed that the court kind of sniffed that out too. I mean, in the back and forth between the court and the Solicitor General, they said, "What was this modeled after?" And he said, "Oh, I don't know." But they saw the two side by side, didn't they?
Oh, absolutely. As Keturah says in our briefing, we put the two ordinances side by side on the same page. So the court could see the village of Stratton's, the court could see New Jersey's, and they were virtually identical. So in essence, what the court said is, we struck down New Jersey's ordinance. That doesn't go into the dustbin of history. It controls what we do today.
Interesting. You know, when you talk to somebody about this decision, Professor McDaniel, typically they would say, well, you must have won on the free exercise clause of the First Amendment. You talked about that. No, it was the free speech clause. And in fact, in Justice Scalia's concurrence, he says just that. Let's take a listen. Actually, let's bring it up on the screen. This is what he actually said. Whereas the free exercise claim, if acknowledged, would merely exempt Jehovah's Witnesses from the licensing requirement, the free speech claim exempts everybody thanks to Jehovah's Witnesses. Professor McDaniel, a significance of that statement.
Well, keep in mind that around this time, about a decade earlier, the Supreme Court had limited the scope of the free exercise clause. And so that might have been part of the background thinking of Justice Scalia there. But he's pointing out an important benefit of ruling on the free speech clause, which you also see in a number of these other cases that were brought by Jehovah's Witnesses. And that's that if the court had ruled under the free exercise clause, its ruling would naturally be limited to the religious claimants that were in front of it. So Jehovah's Witnesses in this case would have benefited, but no one else would have. But now by ruling under the free speech clause, it's basically covering anyone who wants to go to a neighbor's house and speak for any reason, for any cause. And so based on that rationale, the court's holding now benefits everyone.
Very powerful statement. And you saw Justice Scalia, Paul, and Philip, you saw him going that way the whole time, pushing it to free speech and away from free exercise. Why, Paul?
There was a little measure of controversy over the protection the Supreme Court accorded free exercise of religion based on a decision that Justice Scalia authored, Employment Division versus Smith.
In fact, he mentions that in his concurrence.
Correct. And so he was making it clear, we're not going to revisit what we've decided in Smith, but we are going to establish protections under the free speech clause. Which
broadened its effect on everyone, right? Mm-hmm. But let's focus in for a moment, Philip, on its effect on Jehovah's Witnesses. Looking back 2 decades since Stratton, what has been the impact on Jehovah's Witnesses?
So significant. The doors are open. The court has said categorically we have the right to engage in our public ministry, and the government should not try to interpose itself. And as a result of the decision, the resistance, spotty as it used to be, has virtually disappeared.
Keturah, what has been the effect on Jehovah's Witnesses?
I totally agree with what Philip said. It really has helped to resolve any municipal attempts to restrict our work, and most importantly, to resolve them in a neighborly way without the need for litigation.
Now, you have been involved in cases since then, at least one significant case in Puerto Rico that used Stratton as a basis for the decision. That was in 2004. In Puerto Rico, if anybody's been to Puerto Rico, they know that many of the communities are gated or really actually walled. What do they call them? They call them controlled access laws there. How was that affecting Jehovah's Witnesses?
So just by way of background, Puerto Rico had passed this law which allowed neighborhoods to go to the government and seek a permit to wall off and gate their community. But these were public streets and public sidewalks. And the effect of that was that it began to hinder the work of Jehovah's Witnesses to engage in their door-to-door ministry because they were denied access. So Stratton was really key to bringing that case.
Why? Why was Stratton so important to the outcome of that case? Of course, you won. But why was it so important?
Well, just 2 years earlier, the Supreme Court had reaffirmed that Jehovah's Witnesses, like other speakers, had the right to engage in door-to-door advocacy on public streets and sidewalks. And again, all these communities contain public streets and sidewalks.
So that's how it affected Puerto Rico and that controlled access law. But Josh, or Professor McDaniel, excuse me, how did it affect others? How did it affect free speech in general? How did it affect your average citizen, the Stratton case, in its decision 8-1 by the Supreme Court?
Well, if you look, first of all, at how it has played out in the lower courts since the Stratton decision in these intervening 20 years, it's been applied in all types of situations, anything from signage to outdoor speech to handing out pamphlets and leaflets to even street performers. But I think also zooming out, I think one way to look at it is none of us really thinks if we want to cross the street and go talk with some of our neighbors about some issue at a local school or about the garbage collector or anything like that, really, we don't even think twice when we do that maybe I have to run to the city hall before I can do that and get a certificate, get approval. That's something that just doesn't even cross our mind, let alone crossing our mind that could be a criminal violation to do that without the government's permission. So I think really fundamentally, this goes to our attitudes about what we can do, what we have the freedom and the right to do as citizens in our everyday conduct.
Philip, the broader effect.
So the two points, Robert. The first point is that Jehovah's Witnesses don't change. Mm-hmm. The bottom line is that we're going to engage in our door-to-door ministry. But the broader effect, as you said, Robert, Charles Haynes of the First Amendment Center wrote this just after the decision of Stratton. We all owe the Jehovah's Witnesses a debt of gratitude. No matter how many times they're insulted, run out of town, or even physically attacked, they keep fighting for their, and thus our, freedom of religion. And when they win, we all win. That's the point. As Jehovah's Witnesses protect civil liberties, such as freedom of speech, we're not the only beneficiaries. Every single person in this country benefits.
Now, Professor McDaniel, if I'm a government official, what should I take note of regarding Stratton?
Well, Stratton was a resounding decision. It was an 8-1 decision. I think it's clear that the court jealously guards this right, recognizing that it's not only a right that protects Jehovah's Witnesses, it's a right that protects everyone in all types of speech. And so I would think twice before passing an ordinance along those lines, for sure.
Paul, the significance of, at this point, a municipality just passing that ordinance and ignoring this decision, what could happen?
Well, it's clear now after Stratton that the right of Jehovah's Witnesses to go from door to door is firmly established federal law. And as such, a municipal official who violates that could lose his governmental immunity. So that means that that official could be personally liable for such a violation of the Constitution.
Now, Professor McDaniel, let's get a little broader. 20 years to the day since Stratton was decided, what are the potential threats to religious freedoms on the horizon?
Well, something that I see in my clinic a lot is that there's the perception by some that religious freedom in a modern society is of diminished value. It's not as important, or perhaps it's something that should only be protected for one individual's faith, but not for other faiths. And I think what Stratton underscores, and what all these Jehovah's Witness cases underscore, is that what protects a Jehovah's Witness also protects and benefits all of us.
It's interesting that Justice Scalia was very strong on this case. In fact, as he listened to the argument of the village, he had a very powerful statement, just kind of off the cuff, regarding the difference between this country and its constitution and totalitarian governments. Let's take a listen.
The question is how much, how necessary is it? We can all stipulate that the safest societies in the world are totalitarian dictatorships. There's very little crime. It's a common phenomenon, and one of the costs of liberty is to some extent a higher risk of unlawful activity. And the question is whether what this is directed at stops enough unlawful activity to be worth the cost of requiring the privilege of ringing somebody's doorbell.
Professor McDaniel, that speaks to your thought, right? What was he saying?
Well, the government, of course, has a proper role to play, and it has a lot of important interests. Stopping crime, for example, is a very important interest that the government has, but so too is protecting speech, free speech, our ability to practice our faith. And so the government needs to find a way to achieve its interests in a way that, to the least extent possible, restricts the rights of its citizens. And so that's what he's saying, is that we don't live in a totalitarian dictatorship. We live in a free society. And so if we're going to live in a free society, the government just can't blanket require everybody before they go and talk to a neighbor to go and run to City Hall and get permission before they do so. That's just blatantly unconstitutional to do that. Interestingly, though, Philip, Jehovah's Witnesses preach in some way under even totalitarian governments. What are the threats across the world?
Yeah, that's an excellent question, Robert. There are 8.5 million Jehovah's Witnesses worldwide. 400,000 became such just in the last 2 years, during the pandemic, as a matter of fact. And because we witness worldwide under totalitarian governments, or even governments that might characterize themselves as being democratic, we face opposition. And this is a historic battle. I'm reminded of the first case that we took before the European Court of Human Rights. It involved Minos Kokinakis. He was first arrested in Greece in 1938, and over the next 48 years was arrested over 60 times and spent 6 years in jail for no other reason except for the fact that he tenaciously, repeatedly spoke with his neighbors about his faith. 1993, the European Court of Human Rights handed down a decision in favor of Jehovah's Witnesses and Minos Kokinakis. Now, Robert, that was the first of 140 victories that Jehovah's Witnesses have obtained before the European Court of Human Rights.
In fact, you just had a resounding victory just 2 weeks ago, right?
And I'm so glad you brought that up, because just June 7th, 2 weeks ago, the European Court of Human Rights handed down a decision in our favor regarding 20 applications, and they consolidated that into one decision. The case is entitled Taganrog Religious Organization and Others versus Russia. Now, in its lengthy decision, the European Court went point by point through the different arguments raised against us by the Russian authorities, and dismantled all of those arguments. And regarding the concept of preaching to others, the court said this: the court reiterates that the right, I'm quoting, to try to convince one's neighbor is an essential element of religious freedom, citing Kokkinakis. As a matter of fact, Kokkinakis is one of the most cited cases by the European Court of Human Rights. And just to add the final chapter to this, when Russia banned the worship of Jehovah's Witnesses, there were over 175,000 congregants, Jehovah's Witnesses, in that country. So even today, if one of Jehovah's Witnesses speaks to someone about his faith, he can go to jail for doing so. But that has not stopped us from doing so, even though, as we speak, 88 Jehovah's Witnesses are in prison right now, not for anything wrong that they've done, but because they merely wanted to share their faith with others. And so it teaches this lesson. Civil liberties, human rights, are not stagnant. They can be won and they can be lost. They can be strengthened or they can be weakened. The fact remains Jehovah's Witnesses are going to continue obeying God as ruler rather than men.
Professor McDaniel, think about the impact of the totality of the cases of Jehovah's Witnesses have fought and won in the Supreme Court. What has been the overall effect, the collective effect of them?
Well, for many decades now, Jehovah's Witnesses have been on the forefront of protecting and securing rights that all of us today cherish, and also helping to develop a broader and more inclusive view of the First Amendment itself. Going back to those early cases in the 1940s that we saw, that shift in the Supreme Court's view of how it treats the First Amendment, how it looks at the First Amendment, we have the court going from such a restrictive view to really some eloquent language that Justice Jackson mentioned in his Barnett decision. And if I could read it here, it says, if there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in matters of politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word their faith therein. Now that's beautiful language, and it's language that, as a practitioner in the law, that I see time and time again in briefs and in court opinions. It's language that still embodies how we view the First Amendment today. And I think that's just another illustration, along with the decision of Stratton, that without the contributions of Jehovah's Witnesses, the First Amendment might look a lot different today.
Professor Josh McDaniel, Director of the Harvard Law School's Religious Freedom Clinic, we want to especially thank you for your collaboration on this program and the collaboration of the Harvard Religious Freedom Clinic. We do appreciate it. And Philip Rumley, Paul Polidoro, Keturah Dunn, we do appreciate all the work that you do in participating in this program as well. We'd like to also thank all of you in the bar associations, court systems that work with us to accredit this program in 11 jurisdictions for continuing legal education. We had 3,750 with us for our program today, 563 joining us through 10 simultaneous CLE webinars, and 2,650 on our YouTube live stream. For those who joined us via YouTube, a legal summary of the Stratton case is available for download on your YouTube page by clicking description right below your video feed. For those who will be staying with us in their respective state Zoom live streams, we'll have a 5-minute break, and after which we'll close and then continue a brief question and answer session to satisfy your state requirements for CLE accreditation. And for everyone else, thank you for being with us. I'm Robert Hendricks, and this has been a special live stream presentation, The Constitutionally Protected Right to Go Door to Door, How Watchtower v. Stratton Protects Free Speech for All.